I mean, marginally, I won't give sites. I always.
I mean, obviously,
Hi.
we'll talk about Meisner.
Absolutely.
What? Am I usual? I'm usual suspect.
Good morning. We're going to get started. You could please take your seats. My name is Stephanie Spiers, and I'm Counsel of Program Development here at the Law Society. It's my pleasure to welcome you this morning to the 2003 rendition of this popular program, Criminal Law and the Charter. Welcome to our Toronto registrants, as well as those of you watching from our many ILN sites across the province and via web broadcast. I have a couple of announcements for you this morning, actually quite a few. First of all, this program has been approved at the last moment for the Law Pro CLE Premium Credit, so you'll find the form that you need to complete for that in your binder. So you can complete that and submit it to Law Pro. If you do have a cell phone that's on, please kindly turn it off or set it to vibrate. If in the front of the binder you'll find a gray course evaluation form, and this is just a reminder to please complete that before you leave today and drop it in the box that we'll have for you at the front table. Also, for the Toronto audience, we will be videotaping in this room, and this is just to let you know so you'll be aware that your voice or image may be captured on videotape. Finally, I want to explain how the question and answer periods will be proceeding today. We have left time at the end of each panel for a brief question and answer session. During the question periods, we will be taking questions from our ILN sites, then Toronto. If you are in one of our ILN locations, we suggest that you sit where you can be seen by the camera when asking your question, or one person can be chosen from your group to sit in a spot where they can be seen by the camera. As we are limited in time, we will probably not get to each ILN site on each panel. However, as the morning progresses, we will work through each site at least once. Finally, I would like to thank our chairs, Ken Campbell and Jeff Manishen, and all the faculty members for their efforts in putting together an excellent program for you this morning. Ken Campbell has been with the Crown Law Office Criminal Division with the Ministry of the Attorney General for most of his career. He focuses on appellate work at the Court of Appeal and Supreme Court of Canada. He has lectured extensively on a variety of criminal law matters with various CLE providers, the Bar Admission course, and has taught with the University of Windsor. Jeff Manishen is a partner with the law firm of Ross McBride in Hamilton, Ontario, where he practices criminal defense law. He is chairman of the Law Society's Criminal Law Specialization Subcommittee and has also lectured extensively and taught at Osgoode Hall. And I'll refer you to their bios for further details. And on that note, I'm pleased to turn the podium over to Jeff.
Good morning, everyone, and welcome to the sixth installment of Criminal Law and the Charter, or as it's affectionately known, Peace of Mind Time for me on areas that I'm not really sure I know enough about. To give you an idea of how long this program has been going back, the first time we ran it, it hadn't been that long since the Leafs had won a Stanley Cup. Ken and I have worked hard to put together a number of good sessions today with some outstanding speakers, and we'll proceed directly to it. The first one is an issue that we've titled Unreasonable Delay, the Floodwaters Are Rising, and it seems to be that case in a number of jurisdictions. Chairing our panel is the Honourable Madam Justice Leslie Pringle. Leslie was an outstanding leading member of the Criminal Defence Bar for many years and presides at the Ontario Court of Justice, 1000 Finch West, where she has already, in a relatively short period of time since her appointment, developed an excellent reputation as a judge. Katrina Mulligan practices primarily in North York, but as well in the other Toronto venues as well. She's a director of the Criminal Lawyers Association of Ontario and is very actively involved in trying to effect some measure of efficiency in the justice system. Sue MacLean is a longtime member of the Crown Attorney's Office in Oshawa, Whitby, in Durham region, has been involved in the prosecution of many serious and complex cases, and we look forward to her participation as well. So without further ado, I'll turn the matter over to our panelists.
Good morning. It was Jeff who suggested the title for this panel, The Floodwaters Are Rising. And speaking for myself, I think that the title is very apt because in some jurisdictions, not only are the waters rising, but we are practically drowning. in my jurisdiction in North York, Metro North Court, we are now setting dates for trials in August and September of 2004. And since Justice Hill recently said in the Meisner case, which you'll find in your materials, that the limit for tolerable delay, institutional delay, in the Ontario Court of Justice is 8 to 9 months, if you do a little math, you'll see quickly that we are already in trouble. The situation is even worse when you consider that our earliest custody dates that we're setting are now 3 to 4 months away. But Metro North Court is not alone. I believe that in Oshawa, where Sue MacLean is working, the situation is similar. And in Meisner, Justice Hill seemed to be issuing a pretty clear cry for help in the Brampton area, or perhaps it was more of a dire warning as to what would happen if more judicial resources weren't forthcoming in the Brampton area. So, yes, I think it's fair to say that the tides are now high. We all know that delay has profound effects. For the accused with an outstanding charge and therefore an uncertain future, delay really can be exquisite agony. And for victims of crime, of course, it goes without saying that when delay carries on, it can be very frustrating for them, and it can prompt feelings that the system is not taking care of their needs or taking their views into account. And of course, if the public is to respect the system at all, it must work expeditiously to deal with crime. I think that the saying is, justice delayed is justice denied. For judges also, overcrowding and institutional delay have important implications. When the courtroom is full to bursting every day, it means that it's much harder for us to do our job properly. It's depressing when people wait all day to plead guilty and you have to tell them at the end of the day that you can't reach their matter and they have to go over again to deal with their matter. It's frustrating and it's unfair to everyone to begin a trial only to find that you can't complete it within a reasonable time because continuation dates are months away. Even the question of a simple adjournment becomes overshadowed by issues of delay in a busy courthouse. So the question this morning is, how do you as lawyers, both Crown and Defense Counsel, cope with the constitutional implications of delay? What can and should an advocate do to deal with this reality that exists in the courtroom right now? In your materials, you'll see that we've included a terrific paper by Joe DeLuca, who is a defense counsel. The article first appeared in the Criminal Lawyers Association newsletter, and it analyzes a number of recent trends in the provincial court. And Sue and Katrina have both spent many hours very recently summarizing the most recent hot-off-the-press cases on delay. And they've put them together in an excellent chart that I think you will find is very helpful. It indicates the case names, where they were decided, and attempts to go through and tell you how long the delay was, whether it resulted in a stay, and what the factors were, most importantly. And I think that you'll find that it's very helpful. Indeed, I think I'll refer to it quite frequently in terms of various factors as they come up on delay issues. In our brief time this morning, what we thought we would do was attempt to look at 3 specific aspects of the delay issue, both from the defense perspective as represented by Katrina and the Crown perspective as represented by Sue. And the 3 that we wanted to talk about were these. First of all, the disclosure dilemma. When do you have enough disclosure when you're ready to set a date for a trial, and how that impacts on the delay issue. Secondly, the blitz and other backlog strategies that are being employed as what I would see as a short-term measure to deal with the delay issue. And thirdly, the prejudice factor, which many people feel is what makes or breaks the delay argument when it actually comes to court. And we're also going to attempt to leave 5 to 10 minutes at the end for questions. So let me begin, Katrina, by turning to you and asking you about the disclosure question. how you deal with the disclosure dilemma, how much disclosure is enough, and how does a good defense counsel balance the need for disclosure in order to be able to set a date for trial against the inevitable concerns that you may have relating to delay.
All right. Well, good morning, everyone. Disclosure, apart from what Justice Pringle was saying about the lack of available court space for setting dates and having trial dates months and months away, disclosure seems to be the second most likely culprit for causing delay in getting a trial date or having your trial. And therefore, I think all counsel, Crown and defense, should give this issue really careful attention when setting trial dates or preparing for trial. I think the case law has now come to the point where the notion that disclosure is triggered only by a written request by defense counsel is now antiquated. And the cases are now saying basically what I think a lot of defense were arguing before, that disclosure is something that should be prepared immediately. I know in some jurisdictions disclosure is given at the first appearance date, and many jurisdictions have adopted that now. In some jurisdictions, disclosure is given at the bail hearing, so to the extent that it's available. So there's no longer that notion you have to write to trigger the disclosure obligations, but counsel must be diligent in their disclosure requests. When I say that, I think it's incumbent on counsel, defense counsel, once they get their package of disclosure, to go through it immediately. And a lot of times, defense will get disclosure packages, go through the set date process, and then, 2 weeks before trial, perhaps, or 2 months before trial, realize, hey, I'm missing a video or I'm missing something. I don't think you can do that given the case law. You shouldn't be doing it anyways, but given the case law that's coming in before the courts and coming down from the courts, there's a real clear obligation on defense to be diligent in reading disclosure, finding out what you think is missing, and then articulating that in letters to the Crown Attorney. And it's really, in my opinion, not enough to just say, please, I have some disclosure, I need more. I think defense counsel have to write and articulate their position as to why certain pieces of disclosure are being sought if it's not already apparent on the face of the request. Letters have become very important for criminal lawyers. Probably it was the one area of law where there wasn't a lot of paperwork. That used to be the case, and that's now changed, but unfortunately. But the letters from defense must go out to Crowns, and Crowns must respond to those letters. And there is, you'll see from the cases that have been summarized, some very distinct case law on if letters have been written requesting disclosure, they must be answered by the Crown, responded to either here it is, or we're not providing it because we don't think it's relevant or material, or we are attempting to obtain what you're requesting. A lot of the cases you'll see, defense lawyers have written letters for disclosure and they're simply never responded to. And the Crowns pay in the end for their lack of response. Okay, there's cases that say if you don't respond, to at least allow counsel to know what it is your position is on this request issue, then you will pay for that down the road in an 11B application. I think that counsel have to be aware, defense and Crown, that as a case carries on, as the length of time to get a matter to trial increases, courts have said that there becomes a duty, a positive duty on the Crown Attorney to expedite the case. So I say that because it becomes very important, and always has been, but I don't think enough counsel do this, defense and Crown, to put issues on the record. Because you have a system now, or we have a system now, where usually the Crown in the set date court is just going through the files, setting dates, remanding things. And unless counsel puts certain issues on the record, there's no way that a Crown will know, or most of the Crowns who are just seeing the file for the first time, there's no way that they'll know that this has become an issue. And it really isn't fair to them, if I can put it that way, to simply say we're remanding this for 3 weeks. and not put on the record because we're missing this item of disclosure that's being requested. Because there is a positive duty on the Crown at some point in the delay, you have to notify them that this is an issue so that they can take that brief then and say, okay, I'm going to do something, I'm going to undertake to get what council's requesting. And if you're silent on that point, you run the risk of a court later on saying, well, you know, it would have been good if council had said this, and because they didn't, Crown wasn't alerted, and you know, then council eats that delay, okay? One thing that's really interesting is there is now an issue about Crown policies and disclosure. I'm sure most of you have gone to court and said, I'm waiting for a copy of the 911 tape. As part of my disclosure, I've requested it 9 times, and I'm requesting this matter go over 3 weeks to, hopefully I'll get the tape. And all of a sudden you're met with a response. They haven't responded to your letter to that effect, but you're met with a response in court. Well, counsel, in this jurisdiction, tapes aren't prepared, 911 transcripts aren't prepared until the trial date is set. Well, though that's not the place and the time to argue the, you know, the policy itself, counsel can acknowledge that, okay, I understand that's the policy, and I think that certain things can be put on the record, again, padding the record, if I can put it that way, to help counsel down the line when they bring their 11B. What's happening in some cases is that judges are saying, hey, if that's the Crown policy and that caused a delay, the Crown, that's something the Crown has to rationalize here at the 11B stage. Okay, so if you are met with these policies, you can't get this until a trial date's set. That's fine, but indicate on the record, well, if you need this before you set the trial date, then say on the record, I can't get instructions from my client unless I have this tape, if that's the truth. Or I can't estimate trial time until I get this piece of disclosure that your policy says you won't give me until the trial, or until the trial date's been set. So there will be items of disclosure that you will need, that the Crown doesn't think you'll need until the trial, and the Crown will say, well, you can set your trial date now and then you know, get it in the interim. There will be times, and there are many times, and I don't think counsel state this enough on the record, where you will have to say, that may be your policy, but I can't get instructions from the client. I can't estimate trial time. I can't, whatever it is, without that. And that policy may be well and good, but here's my position. So depending on what the item is, you either say to the court, you know, that's fine, I'll set my trial date, and hopefully the disclosure will be provided in the interim, or I understand that's your policy, but for these reasons, I am not prepared and cannot set a trial date. Again, you're alerting the bench, you're alerting the Crown. And down the road, when that transcript comes up on an 11B motion, the judge who's reviewing that has a good idea of just how important this piece of evidence was. Just lastly, and Justice Pringle was talking about this in the beginning, how much disclosure is enough? In other words, does size really matter, is what I like to call this. And yes, it does, and in disclosure especially. Counsel has to be realistic in their requests, okay? You have to be diligent in deciding what is really important for the defense, what is really important and necessary for you in order to set this trial date, and what is simply foot dragging or delay tactic. And I hate to say that, but there is a difference. There are certain items of disclosure that I see counsel saying, I'm not setting a date until I get this, until I get copies of photographs, and mostly it's copies of photographs I see. Now, you have to really question, or you have to really ask yourself, do I need to see this item before I can set the trial date? Or is it something that I can set a date now, bring the matter back in the interim, get your copy of your photograph, or get your copy of whatever it is you need. In the interim, you've secured your trial date, and you really have done everything you can to get an early trial. There has to be a really clear distinction between what is absolutely required to set your trial date and what is absolutely required to conduct the trial. And I think that there's a good issue, or there's a good thing for council to do is to make that distinction, and not just to simply sit there at set date court and say, I need this before I can set a trial date. Down the road, a court will carefully look at everything that council has done, and they will be assessing whether you truly required this piece of disclosure before you could set a trial date, and they'll assess that and take into account your argument about delay. As a last point here, things that council must do for disclosure issues is put on the record the reasons. Never just do a set date and say I'm remanding something for 3 weeks without, I'm not saying make a speech, there's not enough time, but just very quickly summarize what it is you need and why you're asking for the adjournment. Just don't simply ask for a 3-week adjournment and walk out of the court. Never deal with the officer in charge directly with respect to disclosure issues, okay? Because the officer doesn't have any disclosure obligation, the Crown does. And the Crown has to know everything that you're doing because they're responsible for the disclosure. So if you start dealing with an officer directly getting disclosure, you've cut the Crown out of the loop, and later on that might come back to bite you. And time-sensitive material, remember, when your client comes into your office and says, you know, I've got this case, he or she retains you, make sure that you're aware that there are some materials out there that are time-sensitive, tapes that are destroyed after 30 days or 45 days, alcohol standard solutions. Send out your letters immediately. Don't just wait for your first date because you know that jurisdiction will give you disclosure. Send out the letters immediately and secure your timing in terms of the timing of your request. It doesn't hurt. A lot of lawyers have stopped sending out the initial disclosure request letters because we get disclosure on the first date, and that can be very dangerous.
So, Sue, let me just ask you to respond to one thing that Katrina was talking about. She said that defense counsel need to be diligent and they need to make requests in writing. What does the Crown do when it's getting repeated requests in writing from a defense counsel who is perhaps scattered in their requests for disclosure, and the Crown thinks they may in fact be frivolous requests for disclosure? How does the Crown deal with that?
First of all, I agree with the points that Katrina has made, so I'm not going to repeat them. I believe that the Crown has to respond in a timely fashion, whether the Crown feels the request is valid or not valid. There has to be a timely response. If the Crown disagrees with what's being sought, then the Crown should be writing back and saying, let's set a trial and bring your Stinchcombe motion for disclosure to the trial judge. Then you'd have to set a trial date and perhaps a motion date a month or longer prior to the trial to allow, if the court says it is disclosable, then the defense will have it in adequate time to prepare for their trial. But at some point, the Crown simply can't say, oh, I don't think they need it, and just ignore the request. There really is a strong obligation, and the cases are highly critical of the Crowns who do nothing, as Katrina has said, or basically, in some cases, they've criticized the Crowns for what they feel are unreasonable positions with respect to disclosure, which have caused a delay in the process. So the Crowns have to expedite things by getting the trials set and then sorting out those disclosure issues in a litigation form, if we have to, before the trial judge. One of the things I wanted to say in addition to that, there's a case, it's not in my chart because I focused on Ontario cases, and in particular Superior Court cases, but there's a recent case out of the Alberta Queen's Bench called Chan, C-H-A-N. It's Chan et al. It was a criminal organization case involving drugs where the court stayed the prosecution, and the date is September the 8th of 2003, and the site is square brackets 2003 AJ for Alberta Judgments number 1117, and it was drawn to my attention actually this week. And in that case, I wanted to point out that at paragraph 494, it says the actions of the defense in pushing at the boundaries of relevance should impact the amount of time that ought reasonably to be provided to the Crown to comply with the request for disclosure. So there are cases where defense is testing the limits or going into uncharted waters type of thing, and as the complexity of the case increases or issues like that increase, of course, the courts will consider it neutral time, because there is inherent time allowed for disclosure. But it's when it gets past what's considered inherent time that it becomes unreasonable, and then the Crown wears it. So there's an awful lot of obligation on, I think, both sides. But the other thing I want to say based on experience, when I'm in the remand court, I had a student once say, we're waiting for the video disclosure. And I said, when was it ordered? And she said, well, we haven't ordered it yet. I'm going to order it today. Now, I'll give her the benefit of the doubt that she wasn't trying to mislead anybody, but was simply saying we need to review the disclosure, and we haven't got it yet. But the record would have reflected we are waiting for the video disclosure. So the Crowns, I think, have a very serious obligation to, in the remand court, slow it down. As Katrina says, both sides should be putting everything on the record, even though there's that constant pressure, get the list moving. That's where we are in those remand courts. You have to take the time to make the inquiries. And in our jurisdiction, if there's an outstanding disclosure issue, we will send that lawyer out to our resolution Crown and get that person to follow up on it that day to make sure we're responding. And in fact, with the new resources allocated, we are now designating one of our Crowns to be a solicitor Crown to respond to disclosure inquiries, because the volume of paper writing has increased so significantly. There'll be shared tasks, and it won't be one person, it'll be a rotation. But the Crowns have to realize we are now, in many aspects, especially in this area, having to become solicitors and not just barristers. And I think that Katrina's made the same point for the defense bar.
We're becoming just as bad as the civil lawyers.
Oh, some will say just as good.
Let's move to the second topic, which is blitz and other backlog strategies. And Sue, I'm going to start off by asking you about this one, because as the Crown who prosecuted Darlene Morin many, many years ago, you probably have a better insight into strategies used by the Crown to deal with the delay issue than most.
Well, I have to give the credit to my boss, John Scott, who's very forward-thinking in some of those areas about anticipating issues. And he had sent a letter out to the defense bar saying, we have these dates available. If you want them, come and get them. And we're doing the same thing right now. Mm-hmm. And there are blitz strategies throughout the province. And something I've talked about with Leslie and Katrina is there is a tension, in my opinion, between the right to counsel of choice and your right to trial within a reasonable time. Because there may be dates offered, earlier dates offered, that counsel's saying, well, I'm not available. If they'd been offered when the date was set, I would have been, but now I've booked myself up, I'm a good lawyer, I have a busy practice, and that's fair enough. But at that stage, I believe that the Crown shouldn't wear it, so to speak, if the defense lawyer is not available on those earlier dates. And at that point, if there is real prejudice, which we'll talk about later, to the client, I believe there's an obligation on the lawyer to either shift their own cases to accommodate that client who is suffering real prejudice and take one of those earlier dates, or perhaps have another lawyer act for that person. And if the accused wants to keep their lawyer, which they certainly have the right to, and I wouldn't blame them for saying, I want Katrina, I don't want another lawyer. But at that stage then, does 11B have to give way to some extent? And I think it does. I think there has to be a balancing there. And it's very important in terms of the whole issue. I think we were going to talk about the Meisner decision a little bit at this point, and Casey Hill's comments about the fact that when does the clock start to run? And in Casey's, Justice Hill's assessment, he says basically, if dates are offered and the defense lawyer says, well, my first available date is November, but the earliest date offered is January. Well, the time starts to run for the inherent delay from the point that the lawyer was first available until the trial date that's offered by the courts, rather than from the set date to the trial date. And I see the logic in that, because it's not a situation where you're saying, well, because of the system, that entire time frame was unavailable. Now the question becomes, well, how do you get that on the record to have a lawyer declare when the earliest date was? And I think that the Crowns have to ask the question, well, when is counsel's first available date? The cases are quite clear that if there's trial coordination efforts or activities taking place outside of the courtroom, it's different in different jurisdictions, but things have to be put on the record. There either has to be a memorandum attached to the information, or things that were discussed in the absence of the court be placed on the information so that you can say, these were the dates offered, the defense was not available. The Crown has to do that. Otherwise, the record remains silent. Or the defense, on the other hand, has to say, I was available 3 months earlier than the dates offered, and protect their client's interests that way. So there's a corresponding duty on each side to ensure that the record reflects what was actually done. In terms of delay reductions, I mean, it's different in different jurisdictions, so I can only speak to what we're doing in our area, which is, again, when we have available trial time coming up, we are offering those dates to defense counsel and hoping that where their clients suffer true prejudice, that they will be able to take advantage of that. And I clearly acknowledge there are many cases where there is a real prejudice being suffered. And in fact, the Crown's case is prejudiced by delay. So unless there's something further, Leslie, that would be all I'd say at this point.
Let me ask you, Katrina, certainly from the judge's perspective, we are now seeing this happen a lot, is we get the little delay dance going on in the courtroom where the Crown gets up and says their piece, and then the defense feels that they have to put their piece on the record, and really all you want to do is move on and get past it, but everybody feels they've got to put their statement on the record. It does seem that it's going to be important for defense counsel to be clear about what their earliest date is, in light of what Justice Hill said in the Meisner case about when you count institutional delay. Indeed, in that case, it seems like it might even have made the difference. If he had counted the time from an earlier point, there might have been just enough to push it over the boundary of unreasonable delay, and the defense might have got a stay. But they didn't, and in part, it may have been because Justice Hill counted from the first date that trial counsel had available for their trial. What does the defense do about that?
It's a very interesting decision, the Meisner decision, on that point, because it's it is the first decision that we're aware of where the judge says, you know, yeah, the lawyer has to vocalize his first date or her first date, and we count from there. I agree with the calculation to a certain extent, but I think it's just I think Justice Hill is restating the general principles, if I can put it that way, that we already are familiar with. Counsel should put on the record, if they can, that they have dates starting next month. Because usually even busy trial counsel will have a day or two in the upcoming month. Sometimes you have a day tomorrow where you can say, I would be available to conduct a trial if you had earlier dates. In fact, I have dates next month, next week, if you believe you could actually do the trial next week. I don't think we have to take up a lot of time in the set date courts going through our diaries and saying, okay, I have November 14th, November 23rd. I don't think that's realistic. But I think what Justice Hill was saying was that you have to alert the court somehow that you have earlier dates. And we've always been doing that. We've always been saying, I had many earlier dates between now and then. I think what the decision does now is for counsel to get a little more specific, saying, I have earlier dates starting next month or next week. So I think that's very important to do as a result of the decision. If you don't put that on record, if it becomes, because you obviously could become just totally time-consuming to see lawyer after lawyer and crown after crown asking the specific question, then in your motion down the road, in your materials, your supporting affidavit, then you put it in your affidavit that you had earlier dates. And when I'm setting trial dates now, I keep very, very meticulous notes. Very important when I go do my affidavit for 11B or my client's affidavit. And now I put, you know, date offered, first date offered, August 2004. Date I had for first available trial. In my own docket, I'll put, you know, October 27th was available for my own edification. What I'm also doing sometimes in some jurisdictions is I'm writing to confirm that I set this trial date and I have many earlier dates, and if earlier dates become available, please advise me. Okay, now I send that to the trial coordinator and CC it to the Crown. I've never had a trial coordinator phone me back to say, hey, got your letter, Kat, and I got some earlier dates. I'll get the Crown going and we'll see if we can get something earlier. But on my 11B applications, those letters are great. attached to an affidavit, they are insurmountable often for the Crown attorney who never responds to them, or the trial coordinator.
Some crowns respond to those
Some.
letters.
That's it. Also, with respect to Justice Hill's characterization of when we start counting delay time from, counsel should be very careful or very much aware of this neutral time that we've discussed in getting a case to trial. Sometimes that time will be 6 weeks, 8 weeks, where if it's not realistic that you could run the trial next week, you can't say, I could do the trial next week. If you know you can't get your expert there next week, you know you could never get a subpoena out in time, but some days you could, sometimes, like a fail to comply charge, you could do it tomorrow, or you could do it next week. So you have to be honest on the record, first of all. Secondly, the neutral time, many times I have said, when I get my initial disclosure, or when I'm arguing my 11B, there is no neutral time here. When my client was arrested, all investigative notes were complete, all witnesses had been interviewed, everything had been done. There is no new investigation since the date my client was arrested. 6 to 8 weeks, they didn't need that to get the disclosure ready. They needed 2 weeks to photocopy, and that's it. So there's a lot of case law that says, there's this neutral time to get a case going, and it's generally 6 to 8 weeks. That may be the case, but look at your own case and try and neutralize that neutral time or inherent time requirement and say, yes, I understand that's a basic principle, but not for this reason. And you give an affidavit saying, I got my disclosure. Every note was complete as of the date of my client's arrest.
Let's just look lastly at the prejudice issue, because I do think that prejudice sometimes is the issue that will make or break a successful delay application. And Katrina, just if I can ask you briefly, we don't have too much time left, to talk about whether you agree with that proposition that it makes or breaks the delay equation.
I completely agree with that. Often prejudice is a pivotal piece of evidence when a court is looking at whether or not to grant your application to stay a charge. And I remind everyone that first of all, evidence is required. You can't just put in an application saying delays cause prejudice. You have to give an affidavit from your client usually, or whomever you choose. And I'll get into that. Also remember that the evidence of prejudice is, you have to give evidence of actual prejudice to persuade the court to stay your charge. It's no longer enough to simply rely on inferred prejudice. You have to actualize it, okay? I think I'm getting I thought I was getting the hook. You have to also focus the evidence of prejudice on the problems caused by the undue delay, okay? So actual prejudice caused by the delay and not just caused by the charges themselves hanging over your client's head. The types of evidence, I think counsel should get very creative with a caveat. You have to remember that all your evidence can be cross-examined on by the Crown. So get creative, consider the pros and cons of certain types of evidence, but include in your motion an affidavit from your client, from your client's spouse, from your client's children, if appropriate, depending on the charge. From your client's boss, if his or her work has been affected, work product. Get medical letters and reports, if you can. I've sometimes included financial statements. If I'm saying my client has not been able to concentrate on work and I can show financial statements that show a decline in work productivity, I include those. Report cards from school where they show a decline in the marks. Those work well and give a judge a really good picture of what's actually happened to this person. Always, however, prepare your affiants for cross-examination because there's some really interesting things, as we know, that our clients can say that will blow all our work in putting together this motion. So always prepare the affiants. And what I do sometimes is when I file my motion, I include a cover letter saying, here's my motion. Please notify me in advance if you wish to cross-examine any of the affiants. And that way we don't get a situation where we show up for trial, I don't have my client's boss there, and the Crown saying, well, I want to cross-examine. Now, I didn't know, I don't have the boss pulled out of work. This way I can say, well, I included a letter, you never responded, so how would I know? We need an adjournment delay against the Crown. Done.
So, do you cross-examine Sue?
Well, I haven't had a situation where I've had to, but I would. And the reason is when I look at some of the cases, the Crown seems to be blamed for everything that's ever gone wrong in some of the accused lives. And I do think some of these things might have pre-existed the actual charge. And it's clear the case law says it's not the prejudice that flows from the actual laying of the charge, because there can be prejudice such as to reputation things. It's the actual prejudice from the delay. And the Crowns have to be very clear to focus in on what's happened to this person as a result of the delay, not as a result of the charge. And I do think that, for example, where there's some psychiatric or psychological impact, there may have been some pre-existing conditions on that person's health that is complicated or compounded by the delay, but not the sole cause of it. So the court would have to weigh how much of the actual prejudice is caused by the delay as opposed to this person's sad life, which may well be the case. So that would be my answer. Yes, I would cross-examine.
I think we're at about 9:45, and I want to encourage questions because, of course, we have two very experienced lawyers here, and they are also totally up to date, having spent hours looking over the cases. So we are cutting edge, so I'd encourage you to ask questions if there are any questions. Jeff, you're going to check with the satellite sites and find out if they have questions first?
Yes, what we'll do, thank you, Justice Pringle. What we'll do then is work our way down through as many of the sites as possible in the time that we have. The first location we'll inquire about is Barrie.
Don't think there's any questions here. Thank you.
Thank you. We'll go to Burlington next.
No questions here, thank you.
Hamilton. Questions? No questions?
But lens is really, in order to, no questions.
That's how we do things in Hamilton, right? Just give him a Hortons, he'll be fine.
Chances are, he'll more likely stay one of ours than one of the regular ones, because, you know, we're second-class citizens, as it were. At least that's the sense that I get.
Yeah, they do that too in Hamilton. Kenora?
I know. No, we don't. No question.
London?
You made a question? No. No questions.
No, surprise. That's good. Didn't Neil Diamond sing, I am, I swear, and no one answered at all, not even the chair? Niagara-on-the-Lake?
Questions, thank you.
They're leaving.
Question from Niagara-on-the-Lake? No? Okay, we'll go to Ottawa next.
No questions from Ottawa.
Sudbury?
You have one question.
Bless you.
Yay, Sudbury, yay!
We have a question.
I wonder what the court's response would be in a situation where you have 4 or 5 co-accused and one of the counsel is unavailable for, say, 2 months. Or longer. Is one of the Crown may be jumping up and down because of delay. The co-accused may be jumping up and down as well. Is one of the possible answers would be for the Crown to basically split the accused so that they have their trials on the dates that they want, basically?
In other words, to get around the 11B argument.
The question...
Especially if one of the co-accused, for example, is in custody.
So the question then for everyone, both here and on the network, If you have multiple accused and 3 of the 4 of them are available, and one of those is in custody, and one accused, his counsel, is not available, what's the remedy for the Crown? What's the effect of that particular complication on unreasonable delay issues?
Sue, I think that's really for you.
Oh, thanks. The Chan case talks a bit about that because there were multiple accused there, and there was, in fact, a severance at some point. So look at the Alberta case I referred to. But the Crown's going to have to always look at how much time or resources of the ministry in terms of justice system is going to be allocated to splitting up things. If you've got multiple accused, it's going to take weeks and weeks of trial. Are you going to take that court time away from other accused who also need it to have a split up trial? And I don't think you will in most cases where it appears that they should be jointly tried. But the Crown has to always be open to the facts of each case, and I don't think there's a pat answer. The Crown has to consider what's happening. But I think there's also an obligation on counsel, defense counsel, to set aside their other obligations to accommodate the in-custody accused. They have an obligation as much as the Crown does, so I don't think it all flows to us.
Sometimes one of the strategies can be as well to get a judicial pretrial at that point, to have everyone sit down and discuss what the potential for hiving things off or getting new counsel, just having all the lawyers talk with the judge about it so that you can move things along if at all possible.
Just very quickly from the defense point of view, you read the cases, there will be some point where you may be required to bring up the issue of severance. And if you don't, that might be a problem down the road.
Next site, Thunder Bay. We can't see or hear you yet, Thunder Bay. Well, sure. Oh, we can hear you. Do you have questions?
Write them down.
I can't hear them.
Uh-oh. Have you got a large piece of paper and a heavy marking pen? Put your face real close to the camera. We're going to have to untangle that one. Sorry, guys, we can't hear you. Can you hear us? Oh, excellent.
There we go.
He can hear me. We know that. Is there a microphone you guys have?
Yeah, it may not be on.
Wow, still can't hear you. We'll let our internet service provider get to you. We have a jet just chartered on the island, and it'll be out to take care of the technical problems. Sorry. Waterloo?
No.
And Windsor? They said no.
No questions.
No questions. Finally, Toronto, we have a minute or two. Any questions? Go ahead. And the question then for everyone on the network is, there have been issues with respect to federal prosecutions that are so broad in scope with many accused. The question is, from a provincial Crown standpoint, are they reevaluating the need to include every possible accused and ultimately winding up with an overburdened system and an overburdened prosecution?
Instead of breaking off into a lot of little trials.
Sure.
I think I answered that with the question from one of these sites, but the Crown just has to keep an open mind in every case. And I haven't done a multi-accused situation such as being described, so I can't speak for other people. But all I can say is the Crown always has to keep an open mind, be alive to these 11B issues. And if there's people that don't need to be joined, then we should be severing them and dealing with them separately. But you're going to have to look at the impact on the court resources as a whole.
I think sometimes a little judicial pressure to get everybody talking is good, because not only are you talking about severance issues, but you're talking about reasonable positions for minor players, especially in some of the big drug prosecutions, when the real focus is going to be the big guys. And the ones who are on the ends, maybe it's just in everyone's best interest if the Crown gives reasonable positions and they can be weeded out from the outset. So I think there's a role for the judiciary in pruning down those oversized cases, as well as a role for the Crown.
The thing that surprised me is why they insisted on doing it in the first place. But obviously the thing is overweight, top heavy. Is there such a fear? I'm trying to think of what the motivation is. Is there such a fear of having inconsistent verdicts or something like that?
I think it's money.
And
I
the
think
question.
the bottom line comes down to finances often.
All right. Thank you. I think that takes care of the time for this panel, and we'll let Ken introduce the next one. I thank our panelists, and those who wrote the papers that write.
While the next panelists are making their way to the front, maybe I'll begin to introduce them. I'm pleased to welcome as chair of the panel, Madam Justice Feldman of the Court of Appeal. As you may know, Justice Feldman practiced law for some 15 years with Blake, Castles, and Graydon, primarily in the area of civil litigation and administrative law. Before her appointment to the General Division in 1990. She remained there until 1998 when she was appointed to the Court of Appeal. Since coming to the court, she's written a number of important criminal law judgments. As you're probably aware, the Doré case, one example, the retention of fingerprints case, and more recently, Vanda Nelson, the case dealing with the defense of necessity in the context of child abduction cases, and most recently, I guess, White, the case dealing with the admissibility of non-videotaped statements. She's joined with by Croft Michaelson, who's been with the Federal Department of Justice for some 14 years now. He's now the Director of General Counsel in the Toronto Regional Office, and Croft was lead counsel for the Crown on the recent Hetzig and Parker appeals, which you'll no doubt hear about during the course of the panel. They're joined by Paul Burstein, a very respected Toronto defense lawyer who specializes in criminal and constitutional litigation and has argued many important charter-related appeals in the Court of Appeal. Indeed, Paul's been one of the lawyers who's been leading the charge against the legislation criminalizing marijuana possession, and we're certainly grateful for the paper he's written in your materials on the harm principle. Last but not least, Rosella Cornaviera, one of the leading lights of the Crown Law Office criminal, who's possessed of a diverse wealth of experience in both the trial and the appellate courts. And you may be interested to know that Rosella was in a bit of a time warp recently, being the ministry lead in the review being undertaken currently by the Honourable Fred Kaufman in relation to the 696 application into the 1950s prosecution of Stephen Truscott. And we're grateful for the paper that she and Croft put together as well. So, Justice Feldman.
Thank you very much, Ken. Our topic is Parliament Under Siege, Current Challenges to Federal Legislation. And we're focusing on federal challenges because, of course, it's the federal law that impacts criminal law the most. But it's not just charging sections that we're dealing with. We're also going to talk about, or you'll see in the paper, there's prisoners' rights to vote, bail, other aspects of criminal law are affected by many, many criminal statutes. Ken talked a bit about the two papers you've got here. They're two excellent papers. One was prepared by Croft and Rosella, and it's a review of a lot of recent charter challenges to many federal statutes, and it's an excellent overview and right up to date. The other paper that Paul Burstein prepared is an analytical piece on the harm principle in Section 7, and he is now waiting for the Supreme Court of Canada to finally pronounce on his argument, his harm argument in the Clay case and Malmo, Levine, and Kane, which are under reserve in the Supreme Court of Canada. So I commend both excellent papers to you. Now what we want to do is talk about two aspects today of these federal challenges. One is the substantive law aspect, And the other is procedural, sort of what do you do if you want to bring a charter challenge? And we've got extremely experienced people here to tell you about it. So I'm going to start with Croft and ask you to tell us, instead of going over all the charter challenges, if you could start telling us about the history of the marijuana cases and where they stand today.
Sure. I can probably tell you where we stand today on the marijuana cases. Where we stand tomorrow, I'm not so sure I can predict. But the cases are set out in a fair amount of detail in the paper that Rosella and I prepared. So I'll just provide you with a snapshot overview in the next 5 minutes or so. Really, when we talk about marijuana, the first really successful challenge that was brought against the possession offense was advanced in a case called Regina versus Parker, which was decided by the Ontario Court of Appeal back in 2000. And that was a case that had relatively sympathetic facts. Mr. Parker was an individual who had epileptic seizures from the time he was a young child, and he had tried to use conventional medications without much success. And at a certain point in time, he had discovered that marijuana seemed to work in controlling his seizures, and his doctor back in 1987 had determined or said that it was medically necessary for Mr. Parker to use marijuana. The Court of Appeal accepted the trial judge's finding of fact that Mr. Parker did need to use marijuana to control his epilepsy, and therefore found that the broad blanket prohibition that existed within the Controlled Drugs and Substances Act implicated both his liberty interest and his security of the person interest. And the interesting thing about the judgment is that the court said that the security of the person interest was engaged because Mr. Parker was being denied access to effective medical treatment because of the blanket prohibition. He was put in the untenable situation of having to choose between committing a criminal offense and being exposed to liability for prosecution and being able to access medical treatment. So the court didn't have terrible difficulty in looking at the provision and considering whether it was saved by justified by a principle of fundamental justice, and finding out that it wasn't. And so the court essentially pronounced that if you're going to have a prohibition against marijuana possession, you also have to have an exemption, a medical exemption. And the position of the Crown was that we did in fact have a medical exemption scheme in another part of the Act. It was open under Section 56 of the Controlled Drugs and Substances Act for the Minister of Health on application of an individual to grant an exemption for any valid medical or scientific purpose. And the court said that that was unfettered discretion, and the charter rights of individuals cannot be dependent on unfettered discretion. So you've got to do something else. So accordingly, they found that the marijuana prohibition in Section 4 was invalid and suspended their declaration for a period of 1 year. Now, at the same time, that was on the medical front, on the medical use of marijuana. There was a successful challenge. At the same time, on the recreational use of marijuana, we had individuals who were coming forward in a series of cases, Regina versus Mulligan out in British Columbia and Regina versus Clay in Ontario. And those individuals were contending that there's a broad harm principle that prevents the state from criminalizing activities that aren't harmful. And they contended that marijuana possession on its face isn't harmful enough to warrant criminalization. And in British Columbia, the BC Court of Appeal accepted that there is a harm principle and said that the harm principle as a principle of fundamental justice constrains Parliament from criminalizing conduct that is not harmful. But they said as a charter requirement, Parliament only needs to have a reasoned apprehension of harm that is neither trivial nor insignificant. So they said when we look at the harms underlying marijuana possession, we cannot say that they are trivial or insignificant, and therefore we're going to accept that the prohibition against possession is okay for recreational use. Justice Prowse of the BC Court of Appeal adopted a different standard, and she said that for Parliament to be able to act, there has to be a reasonable apprehension that the conduct would cause serious, substantial, or significant harm. And not surprisingly, applying that test, she said that you could not criminalize possession of marijuana. And those cases, Regina versus Mount Mulligan and Regina versus Clay, which largely followed the same reasoning as the BC Court of Appeal, are now pending in the Supreme Court of Canada. And I expect we'll have the judgments on those within the next couple of months. In response to the Parker case, the government came up with a medical exemption scheme and developed a regulatory approach, and it's called the Marijuana Medical Access Regulations. And not surprisingly, perhaps, in a case that we refer to as Hitzig versus the Queen, the regulations were attacked. And a number of applicants came forward saying that they needed to use marijuana for medical purposes, but the regulations imposed so many barriers that they effectively denied them access to marijuana for medical purposes. They argued that the government had not really come up with a valid medical exemption scheme, and therefore, in the result, you should declare that the possession offense is again invalid. The Court of Appeal just less than 2 weeks ago released its decision in Hitzig and unanimously dismissed the Crown appeal. We had lost at the trial stage. And the court found that the regulations did indeed give rise to threshold violations of Section 7 rights because the regulations in requiring individuals to apply for exemptions necessarily interfered with the right of individuals to choose effective medical treatment. But the interesting part of the decision is when they go to consider the principles of fundamental justice. They said there's a threshold violation, and we had argued that nonetheless the threshold violations were justified. And the court said that the regulations, because they effectively drove people to the black market to purchase marijuana, the regulations were in violation of the principle of the rule of law, that you cannot have a medical exemption scheme that is dependent on the black market. And so what the court did was they went through the regulations and excised out the provisions that they said effectively drove people to the black market, and said as a result that they had now come up with a constitutionally acceptable medical exemption scheme, which was important because the court had said that during the time frame when you had a medical exemption scheme that was constitutionally invalid, the Parker Declaration of Invalidity was also in effect. So between the time of July 31st, 2001 and October 7 of 2003, the possession of marijuana as an offense in Ontario was not constitutionally valid. And what they did in another case, a case referred to as Regina versus JP, which you might have heard about, where lower court judges had said there was no offense of possession, while they rejected the reasoning used by the lower courts to reach that conclusion, at the end of the day, they said that Mr. JP was entitled to rely on the ruling in Hitzig, and therefore, because he had committed his offense back in, I think, 2002, he could not be convicted of the offense of possession of marijuana. So that's sort of where we are today. As we stand today, we have a constitutionally valid possession offense in Ontario, and we have a constitutionally valid medical exemption scheme. But in the Hitzig case, the court did note that if further barriers come to light down the road, then they may have to revisit their judgment. So where we'll be tomorrow or next year, I can't say.
Is it fair to ask you whether those cases are currently under appeal?
Yes, is it fair to ask you whether those cases are currently under appeal?
Well, I mean, certainly, I can't say. I mean, we have 60 days to decide whether we'll seek leave to appeal. And, you know, there's a whole process that's undertaken within government when you're looking at the implications from different decisions. So we'll have to wait and see.
Okay. All right, so Paul, going away from the substantive now, you've had to take on clients and think about bringing these types of challenges in several of these cases. What do you do when you have to figure out how to bring one of these challenges and what kind of record you have to prepare and what remedy you're going to ask for? What's the process from the defense side?
Well, contrary to what Croft and some of his colleagues at the Department of Justice would have you believe, these constitutional challenges to the various sort of aspects of the marijuana prohibition were not hatched while Alan Young and I were sitting around a giant bong. Well, at least that's not how I got involved in the scheme. But on the other hand, the genesis of these constitutional challenges does involve speaking with the kind of people who would be involved in that kind of activity. And what probably doesn't come as much as of a surprise to the people sitting in this room, the evidence that we gathered when we were thinking about this way back in 94 and 95, when Mr. Clay first approached us, was that the kinds of people that you might find sitting around that giant bong smoking marijuana included doctors, police officers, law students, lawyers, and yes, even some judges. And as Alan Gold is often fond of saying, at least with respect to 24.2 of the Charter, defense counsel is often better off defending the rights of those other people who will not likely ever find their way in front of a criminal court than the constitutional rights of their own clients. I guess in light of the, I don't know, half a dozen or a dozen constitutional challenges that I've had the privilege and pleasure of being involved in over the last decade or so, I suppose I formulated, not so much formulated, but recognized that there's a sort of an equation. And I don't know if it's additive or anything like that, but there's sort of three concepts that you have to bear in mind if you want to try and strike down a criminal prohibition. Humanize, sympathize, decriminalize. And what I mean by that is a lot of what sort of Croft alluded to in his summary of the cases. The first thing you have to think of doing is how am I going to humanize the unconstitutional effects that I'm going to be arguing at the end of the day should result in striking down this legislation. Because if you can actually humanize those effects, put a face on them, it's more likely the judge hearing the application will sympathize with the plight of those who are adversely impacted. And if you can get the judge to sympathize, you will get the judge to decriminalize. Hence, humanize, sympathize, decriminalize. Yes, the legal arguments are important. If you didn't have a legal argument, you wouldn't even be thinking of bringing a constitutional challenge. But it's certainly my position that the legal argument is not even half as important as the evidence that you will muster. Case in point, what Croft didn't tell you, because of course he was talking about sort of the successful constitutional challenges, but the Court of Appeal decided almost the exact same legal argument about a year earlier from Hitzig in a case called Wakeford. Now, Mr. Wakeford had a number of different cases, but he brought a challenge to the sort of, I guess, offense provision and the then existing exemption scheme on the basis that it didn't allow for a reliable and safe source of supply for him, even though he'd been granted an exemption for his medical needs. Well, the evidence that Mr. Wakeford presented, while it was indeed compelling, it didn't lead to the findings of fact that he really was in dire need of a government supply. So his case in the Court of Appeal failed. But if you read through the court's judgment in Hitzig, I think you'd see quite convincingly that the court repeatedly refers to the evidence, the record, the findings of the trial judge. So even though it was the same legal argument in both cases, you ask yourself, well, why did it succeed in one case and not the other? Well, apart from sort of the strict legal analysis that the findings of fact in Hitzig supported the legal argument, the fact of the matter is that the applicants in Hitzig were much more sympathetic. Unlike Mr. Wakeford, who had become a bit of a pot celebrity and had no problem having people supply him with his medical marijuana, the applicants in our case, in the Hitzig case, they had very compelling circumstances and they couldn't get their medical marijuana. And indeed, it was clear in the judgment of both Justice Letterman at trial and in the Court of Appeal that they did raise a level of sympathy that motivated the court to take action. Simply put, it's not enough to sit around your office and construct the hypothetical person. I realize that the case law is clear that you're entitled to argue constitutional challenges on the basis of reasonable hypotheticals. But the fact of the matter is, if there's no real face to that reasonable hypothetical person, it's not going to motivate the judge or the court to take action so dramatically as striking down a piece of legislation. Irrespective of whether you're arguing your case on the basis of the harm principle, I'm firmly of the view that you have to present concrete examples, not necessarily just with respect to your client, but from others who are affected unfairly and unjustly. Present the court with real people. So where do you find evidence that supports your constitutional challenge, that supports your claim that this law is unnecessary or that the law is ineffective or that it's overbroad or any of those things? Well, I suggest that you start by looking in law journals for any kind of commentary on the law. If there's nothing there, speak to academics who you may know or have heard have written commentaries on the law or who have something to say about it. If not there, obviously always go to the legislative debates that preceded the enactment of the legislation. Was there any opposition to the enactment of the legislation? If there was, get in touch with the opposition politicians and find out where they formed their opinion, on what evidence did they have. Look for interest groups who may have opposed the law in legislative committees, royal commissions. I got to tell you, if you can find a royal commission or some kind of commission of inquiry that criticizes the enactment of the law that you're challenging, you're in a pretty good position. And also, of course, look to other jurisdictions. But what I'd say most importantly, don't just throw the information at the trial judge and then say, here you go, I leave it with the court. Because the fact of the matter is, not only is it unfair to the judge, it's just not effective advocacy. If you look at the recent corporal punishment case, and you read Justice McComb's decision at trial, he notes that there were dozens of volumes of affidavits of experts and yet more volumes of cross-examinations. I mean, a trial judge with their sort of busy day-to-day activities in court isn't going to find the time to sort through that material that easily. Provide them with the summaries, provide them with the guidance that they need to sort through it. I think one of the two things that Alan and I did back in the Clay case in '97 at trial that most greatly benefited our challenge was that we did that in so much. Not only did we provide the judge with summaries, but we provided the judge with an enumerated list of legislative findings of fact that we urged the judge to find, irrespective of whether or not he was going to ultimately agree with our legal argument. And as Croft, I think, will deal with in a moment, the concept of legislative fact, while being interesting and in some way awkward for the litigation process, is critical to appellate review of any constitutional challenge. And what I mean by that is even if you succeed, you have to remember you're playing for the appeal. Because if you do succeed in striking down a piece of legislation, it's not like the feds and the province are just going to lay down and forget about it. So you want to make sure that you get those legislative facts found in your favor, or even if you lose, so you can go and make your legal arguments again in front of the Court of Appeal with those facts supporting you. And finally, the other thing that you have to do when you're formulating your challenge is think about the remedy. That is, spell it out. Don't just think you're going to go into court, you're going to be successful, the judge is going to agree with you, and then the judge is going to say, well, what do you want me to do, Mr. Burstein? Well, I want you to get rid of this law, Judge. I mean, just do something. Just take your criminal code and tear that page out. Figure out the wording of the order. Because, as I'm sure you know from the jurisprudence on the remedy, there's lots of different things a judge can do, even if he or she finds a violation. They can strike it down, they can read it in, they can sever, they can suspend the declaration. You want to be able to help the judge not only decide why it is he or she should choose which one of those things are appropriate, but if you're going to ask them to rewrite the legislation, give them the rewritten version of the legislation. Write it out for them. Hand it up. Or if you're going to come up with some creative mandatory order, figure out who you're ordering to do what. So think it through. Provide some help to the judge, because the more help you provide the judge, the more persuasive you're going to be, and the easier you're going to make it for them to agree with what you do. And so ultimately I say, make it easy for them. Provide them with a human face to the issue and help them with their task.
Thanks, Paul. That was great. The last point I think is particularly useful from the judge's point of view. You hear the case, you hear the argument. If you agree with it, you have to decide what to do. And then the judge looks through and isn't totally sure, if you haven't told him or her exactly what remedy is being asked for. And the judge may think you're asking for a certain remedy or believe that, and you may be very surprised that you thought you won, but then you don't really get what you want because you haven't exactly explained to the judge what remedy. The judge may not want to give that remedy, but at least you've ensured that you made it clear exactly what you wanted to achieve. Croft, briefly, can you respond from your side? What record do you respond with when you're meeting a charter challenge? And of course, you got the Section 1 argument as well to deal with.
Mm-hmm. Excuse me, I will be brief, keeping an eye on the time. But I think Paul did raise one good point, which is that if you're launching an attack on a legislative provision, it would be unheard of for the Crown to walk away from the decision if they lose at the trial stage. There will certainly be an appeal to a provincial appellate court, and there will almost invariably be an effort to pursue an appeal to the Supreme Court of Canada. I mean, because that's just the way it goes. And so when we are looking at presenting our record, we actually focus very closely on building the record. Now, the nature of the record that we can use depends to some extent on the age of the provision. I had a case a few years ago where the codified defense of duress was under attack. Well, that provision had been in the criminal code since we first had a criminal code. And there's not much that you can produce in the way of a record to explain why Parliament adopted it or why it's necessary to have such a provision. But certainly, since we've had a charter, I don't know that people really appreciate this, but the Minister of Justice has to certify all legislation as constitutional before it goes to Parliament. So what that means is that internally within government, there's been an assessment that legislation is constitutional. And on more recent legislation, we will actually start building the record in justification of legislation while we're going through the process of putting together the legislative provision. If it's particularly something that is novel or new and that we think will be challenged, you will see an effort made to get evidence before committee and we'll get the transcripts, and then we'll make sure that we have all those in a database prepared to file down the road. So, I mean, the record is very important from a government perspective, and the nature of what we have is really highly dependent on the age of the offense provision.
Thanks, Croft. All right, we're going to switch focus now, and I'm going to ask Rosella to talk about the concept of the dialogue between Parliament and the courts, and how that's affected some of the cases. Rosella?
The notion of a constitutional dialogue was discussed in a case called Mills, and before that in a case called Rand. And essentially a dialogue is what the courts have considered the interaction that exists between the court and Parliament when it's dealing with a case where Parliament has enacted responsive legislation. Responsive legislation is that legislation that Parliament offers after a court has already declared unconstitutional its predecessor legislation. For example, in the Mills case or in the Dara case, and two cases that were released last year in October, the voting rights case in Sauvé, and as well the bail case in Hall. And I'm going to elaborate on those very briefly. But I think what we can take from the four cases is that if you're looking to determine what approach a court will take to an assessment of the responsive legislation that you may be challenging, you have to look and see whether there's three elements that have been met. If these three elements are met, the court is likely to defer to Parliament's choice of legislative scheme that it puts forward in the responsive legislation. And so this is going to give you some kind of a guideline or framework to assess where the court may go on your own challenge. The three elements are: one, if the responsive legislation is respectful of the court's decision that had originally struck down the prior legislation, then the court's going to be very interested in that. That is, if the responsive legislation addresses very carefully the constitutional impediments that had arisen before, the court's going to want to see that, or at least evidence of that. So the Crown's going to be tendering some evidence of minutes of committee, legislative record to show that Parliament was very careful in crafting legislation that was responsive to the problems that existed initially. The second element is just that. The Parliament was very careful in crafting the legislation. That is, it wants to see that Parliament has considered the various interests that are impacted by the responsive legislation and by the issues that arose in the prior case. So it wants to see that also Parliament can articulate the policy reasons that would drive it to enact legislation that fulfills an objective based on other policy considerations that the prior court decision didn't really address. I'm going to elaborate on that in a moment, and you can see that arise, for example, in the Mills case. And I know I'm talking quickly because I see that the clock is ticking. The third element is that the court wants to ensure, of course, that legislation is otherwise constitutionally sound. Now, if these three elements are met, the court will most likely conclude that Parliament has engaged in a constitutional dialogue with the court. The court renders its decision, Parliament responds to that decision, the court takes a look at that, and if it's satisfied that Parliament intended to enact constitutional legislation and did so in a manner that is respective of the court's decision, it will most likely defer to Parliament's choice. Now, that whole approach is gleaned, I think, from four cases, and I can tell you what those are, and you can look at them at your leisure. The first is Mills, that was decided in 1999. You'll recall that in Mills, Parliament had responded to the common law scheme that the court created in O'Connor that dealt with medical records and the production of medical records in sexual assault cases. The second case is Dara, that was decided also in 1999. In that case, you'll recall that Parliament had enacted legislation that was responsive to the common law scheme in Seaboye, where the court had struck out the rape shield law. The third case is Hall, that was decided last October. There, the court had previously struck out in Morales and Pearson the public interest, the tertiary ground for denying bail. And in Hall, the court considered the legislation that responded to that. That is, the legislation that said that bail could be denied if it was necessary to maintain confidence in the administration of justice or for any other just cause. And the fourth case is Sauvé, where that's also October 2002. It's referred to in the paper as well. Parliament responded to Sauvé number 1, and Sauvé number 1 was dealt with a provision that denied the right to vote to all inmates, the right to vote in federal election. Sauvé number 2 had to do with the validity of legislation that Parliament had enacted saying that the right to vote was denied to only federal inmates. And in that case, the court didn't defer to Parliament. And you can see that there are some elements we can take from Mills, and it kind of follows the same structure that I set out at the outset, that where the court is responsive to the, where Parliament is responsive to the court's decision in the original case, then the court might defer to Parliament's choice. But in Sauvé, it wasn't that at all. Now, I don't want to go into much detail in the cases, but I did want to bring a few significant points to you in the 90 seconds I have left. When you're trying to discern whether or not your challenge is going to succeed, take a look at Mills. And Mills talks about the relationship between the courts and Parliament. And if the Crown can point to those elements that I've discussed, that is respect for the court's decision, if it can point to its policy reasons for denying a right, or for placing a limit on it. And you can see that the Crown is going to be tendering all kinds of legislative record to support its limitation. The court can, I think, articulate and respond to the policy decisions made by Parliament. It's pretty likely the court will defer to it. In Sauvé, the court didn't defer to it because Parliament really couldn't articulate, according to the majority of the court, its policy reasons for completely denying the right to vote to federal inmates. And so it said that it's not enough that you simply try again. You have to show that you're respecting the court's decision and that you're responding to all the constitutional infirmities of the first decision. Now, in Mills, it was really significant because prior to Mills, we thought that when a court set out a common law scheme that governed certain rights, accused rights, and the public interest, that scheme constituted the minimum constitutional standards, and that any legislation responding to that decision had to at least meet that standard. In Mills, the court said that wasn't necessarily so, that it was open to Parliament to make other schemes up that were responsive to the first case, and that it was going to respect Parliament's choices where there's a range of options available. And I think that the courts have shown that it's going to maintain that posture towards Parliament as long as those three elements are met.
Thank you, Rosella. We wanted to say more, but I don't think, I think the hook has come.
Maybe we can just see if we can ask, see if we get some questions from some of the other sites. Why don't we start with Barry?
Thank you.
How about Burlington?
No questions here.
Hamilton?
No, thank you.
Kenora?
No questions.
There, we heard.
Kenora? London?
Is hash oil treated any different than marijuana?
I take it he means in law.
Yeah, no, that's actually a very good question. Certainly, the judgments to date have focused on cannabis marijuana, and there hasn't been any justification put forward by medical users as to why they need to use cannabis resin or hashish. I mean, and I think that so the bottom line is it's only cannabis marijuana that has been engaged so far, and I think an argument relating to cannabis resin would be far more difficult to make.
It would, based on the evidence, because part of the premise of why cannabis marijuana should be exempted is because it's more than just the THC that provides some medicinal benefit, whereas the cannabis resin, hash oil, or even hashish is strictly limited to THC. So unfortunately, it's just not as easy to make the same kind of justificational arguments.
London?
Nothing further.
Niagara-on-the-Lake?
No questions, thank you.
Thank you. Ottawa?
No questions from Ottawa.
Sudbury?
Do we have any questions? No questions from Sudbury, thank you.
Thank you. Thunder Bay, we're still having technical difficulties with, which we'll try and fix in the break. Waterloo?
One question. Are there any known challenges to the incest provisions of the criminal code that might be somewhat analogous to the same-sex challenges?
I'm not aware of any Section 15 challenges, but actually there was a challenge to the incest provisions based essentially on the harm principle. It's referred to in my paper about page 24, 25. It was a Nova Scotia Court of Appeal decision, 1996. It actually is sort of an interesting prelude to what Alan Young and I argued in the Clay case, but I'm not aware of any Section 15 challenge, and I'm not aware of any similar challenge in Ontario to the actual incest provision.
Thank you.
Windsor?
No question.
And do we have any questions here in Toronto?
I was very interested to hear that, as a matter of good practice, the federal department builds a record as to the constitutionality of any new law or any bill introduced into either House or Parliament. My question is, number one, is that record available to a challenger? And number two, is that practice required by law or just a matter of good practice?
Just so I could repeat the question for the other centers, the question is pleased to hear about the building of the legislative record for the courts in these kinds of cases, and is the record available generally?
It's, I would say what we tend to, in terms of collecting the material together, what we tend to do is pull together the information that evidence at committee, submissions that may have been made by stakeholder groups during the consultation phase. Whether the material is or is not available to a challenger would be dependent on whether it's caught by the disclosure rule. I mean, we've had individuals in the past who've made requests, very broad requests for information that's in the possession of the federal government. Maybe caught by disclosure rules, maybe caught by an access to information request. There are different ways that one can go and get it. If it's a matter of public record, we'd probably be more likely to say, well, pull it together yourself.
But if the second part, or the second question...
Is it required by law? No. Yeah, no, Ken, it's not required by law. It's really a matter of good practice, because we know down the road we're going to have to pull it together anyway. So really what it is it's, and we do it in instances where where it's more novel legislation, or legislation that we think is probably going to be challenged, because we know that defense lawyers are going to challenge this. And so it's a matter of good practice saying, let's get it together now, rather than pull it together 3 years from now. And we've got the minds who've been working on this. They've got the material at hand. Let's pull it together and have it together.
Well, on behalf of all of you, let me thank the panelists for a great panel. And maybe we can take our break now for about 10 minutes or so. your law, yes, and here's the 3 points that you need to know, and here's where they come. Thanks very much. Yeah, that's what I said. That's what I said.
I was listening to you and I said, this is